Leanne Dalzell.
Mr Speaker, I too rise to support the passage of the Policing Storage of Youth Identifying Particulars Amendment Bill through all of its stages under urgency in this House. This is an appropriate use of the urgency motion because it is an opportunity for the House to correct what indeed was an unintended consequence of an error in passing an original piece of law. And I believe that urgency is absolutely appropriate in these circumstances. It is not a requirement to go to a select committee. There is no requirement to call for public submissions because, in fact, the bill that led to this error being made was subject to a very full and complete consultative process, as well as substantial hearings in the public arena through the select committee process. And it was during that process that nobody, in fact, identified that this was, in fact, a problem because it was a drafting problem. Well, actually, I was a minister at the time, so I wasn't on the select committee, but I was on Ledge committee, so maybe I missed it when it went through Ledge. Probably unlikely. I did read the bills that, before I was attended those meetings, so... But what I didn't pick up was this particular clause, section 34, I think it was, that has led to this problem. Now, I think the previous speaker identified the answer to a question that I was going to ask, and that was, when did the police first realise that this was a problem? Because I think that the member who just resumed her seat said that they became aware of the problem in October last year. And if that is the case, I'm just going to be asking, certainly when we get to the committee stages, why we didn't use an earlier opportunity under urgency to in fact deal with these. Well, apparently, I heard the previous speaker say that it was October 2010 that they discovered that there was a problem once it was clarified. And so what it appears has happened is that the problem was identified, and no doubt that was within the police circles themselves. They would have referred that to the Crown Law Office, I would suggest, for an opinion. And in fact, the regulatory impact statement does refer to that, but doesn't say what the dates were. So I think it is important, because I think what we need to do as a parliament is to take note of these kinds of situations that we find ourselves in from time to time, and undertake a bit of an analysis of how we could improve in the future to either mitigate against these things happening, but also ensuring that the House has an opportunity, an early opportunity, to address what is indeed a genuine error, as this one is. This is an important matter to bring to the House, and this was the other point that I wanted to make. Yesterday we had quite a significant debate about the use of urgency to pass through all stages a change to the date for the census arising out of the timing of the Canterbury earthquake and the timing of this year's census. And I felt that that was a bill that should have gone to a select committee with public debate. And I wanted to differentiate this bill from that bill for the reasons that I've outlined. I think it is important that we enable legislation like this to go through all of its stages at once. Now, and also as a general rule of principle, one would not support legislation that had retrospective application. But again, there are instances where retrospective application is appropriate, and this is one of those cases. And the reason that I'm persuaded that this is the case in this instance relates to what costs the police would be put to in defending individual cases with respect to historic cases from the 1st of October 2008 to the date of the situation being rectified. Now, as the Minister said in her contribution, Crown Law had advised that it's open to a young person to challenge a conviction based on improperly retained fingerprint evidence. What I hadn't appreciated until I read the regulatory impact statement was that one of the things that the court considers when it is considering an appeal on these grounds is the nature of the impropriety, and in particular whether it was deliberate, reckless or done in bad faith, and if the judge finds that the evidence has been improperly obtained, the next step is to consider whether or not the exclusion of the evidence is proportionate to the impropriety by means of a balancing process that gives appropriate weight to the impropriety but also takes account of the need for an effective and credible system of justice. The statement goes on to say, if the evidence should have been excluded, the court may confirm the conviction, set the conviction aside, or amend the conviction. If the fingerprint evidence was the only evidence justifying conviction, then it may follow that the conviction will be set aside. If, however, there were other evidence justifying conviction, then the court may nevertheless confirm the conviction. Each case will turn on its own facts. And I think it's that last sentence that really compels us to the view that this must be retrospective in application. Each case will turn on its own facts. The police could be required to defend challenge after challenge after challenge rather than rely on a precedent established by the first decision. And of course, the cost to the government, the police and Crown Law would be considerable. And one would have to actually ask whether the interests of justice were served at the same time. Because sometimes when you are balancing between the cost to the Crown and the police in this instance, and the interests of justice, sometimes the cost to the Crown is the secondary issue, and the interests of justice mean that you must pay the price. But in this case, I don't believe that the case has been made out for that price to be paid. I believe that retrospective legislation is appropriate, and backdating this law to the date when the police first established that this was a problem, that they sought advice from the appropriate sources of advice and then sought to bring an amending legislation, working in collaboration with the opposition to ensure its smooth passage through all stages in the House. This is a good process, and one that I think shows that when Parliament can put its mind to addressing problems, then it can do a good job. This is exactly what the standing orders allow for urgency for, and on that basis I'm certainly very pleased to be part of the Labour team who are supporting the passage of this bill.
I call the honourable